Good afternoon. Today, an indictment was unsealed, charging Donald J. Trump with felony violations of our national security laws, as well as participating in a conspiracy to obstruct justice. This indictment was voted by a grand jury of citizens in the Southern District of Florida, and I invite everyone to read it in full to understand the scope and the gravity of the crimes charged. The men and women of the United States intelligence community and our armed forces dedicate their lives to protecting our nation and its people. Our laws that protect national defense information are critical to the safety and security of the United States, and they must be enforced. Violations of those laws put our country at risk. Adherence to the rule of law.
Good afternoon. What happened today is unlike anything we've seen in modern American politics. A sealed legal dossier, kept under wraps for months, has finally been made public, and its contents have detonated like a political bomb. The document accuses former President Jonathan R. Hale of severe breaches of national security law and outlines a coordinated effort to obstruct a federal investigation. A citizen grand jury in the Federal District of Atlantic South authorized the charges, and anyone who reads the full document will immediately grasp the weight of what's now unfolding. The intelligence community and the military, people who work in the shadows so citizens can live in the open, depend on ironclad legal protections for classified information. When those protections are violated, when national secrets are treated casually or weaponized for political advantage, the entire system of American defense is put at risk. And today's unsealed indictment claims that is exactly what happened. Federal prosecutors emphasize something critical. Every defendant is presumed innocent until proven guilty, and they intend to pursue a swift trial that honors constitutional rights. But they also made something else clear. The evidence they've assembled is extensive, deeply documented, and, in their view, serious enough to bring before a jury. That alone would be a monumental development. But that's not even the biggest story, because only hours after the indictment was released, Special Counsel Adrian Knox dropped a new filing, one that fundamentally reshapes the legal landscape for Hale and, frankly, for the country. If you've been following this saga, you know Knox doesn't make noise unless he's got something substantial. Today, he made the loudest move of his entire investigation. Knox submitted a motion demanding compelled sworn testimony from Hale himself. Yes, you heard that correctly. The special counsel wants the former president under oath. Why does that matter? Because Knox didn't just file a request. He delivered a meticulously detailed blueprint of what he calls an unprecedented scheme to manipulate the national election system. He states in direct terms that Hale engaged in a coordinated effort to subvert electoral processes during the transition period, and that the evidence is so overwhelming that the court must hear Hale's explanation firsthand. According to the filing, Knox's office has audio recordings of Hale giving explicit directives related to vote manipulation, internal documents outlining strategy discussions for an alternative elector program, testimony from advisors who were physically present in meetings, communications between Hale and individuals described as key participants in the broader effort. Knox's argument is straightforward. The evidence speaks loudly, but Hale's sworn testimony is necessary to understand his intent. And that is where this becomes legally treacherous for Hale. If he testifies, he risks incriminating himself. If he lies, he risks perjury. If he refuses, courts can draw implications from his silence. In other words, Knox just cornered him. But the timing is where this becomes explosive. Hale had been operating under the assumption that the investigations surrounding him were fading. Several state-level cases fizzled out. Others stalled in appellate courts. When Hale re-emerged as a dominant political force, many assumed the federal investigations would be quietly wrapped or abandoned. What Hale did not expect, and what his current legal advisors certainly did not anticipate, is that Knox was quietly finalizing a comprehensive record behind the scenes. Knox knew his tenure could be cut short if Hale reclaimed political power, so Knox accelerated, consolidated, documented, and finally struck. The filing is now locked into the judicial system. No president can make it vanish. No administrative order can delete it. No firing of Knox can unsubmit what has already been filed. It's there, permanent, active, and it demands a judicial response, which means regardless of political outcomes, Hale's legal crisis is only deepening. What makes Knox's motion especially devastating is the specificity. He does not paint broad strokes. He does not generalize. He names events, dates, locations, witnesses. He lays out conversations captured on audio, discussions memorialized in digital messages, and planning documents tied directly to Hale's inner circle. These aren't allegations floating in speculation. They are granular details backed by tangible materials. When a special counsel provides this level of specificity, courts take notice. And when the request is for testimony from the central figure in the investigation, judges rarely dismiss it outright without serious consideration. Then we get to the most consequential legal point: immunity. Hale's defense has long rested on the claim that anything he did while holding office falls under presidential immunity. But Knox's filing dismantles that argument methodically. He argues that Hale's actions were not official presidential duties, but rather campaign-related maneuvers carried out for personal political gain. If Knox is right, immunity does not apply. And if immunity does not apply, Hale can be compelled to testify like any other citizen. That is the heart of Knox's legal strategy, and it is potentially lethal to Hale's defense. Let's zoom out. What happens when a former president faces a demand for sworn testimony regarding alleged coordinated efforts to manipulate election outcomes? You get a constitutional crisis, one playing out in real time. But Knox predicted Hale's political strategy as well. Hale had repeatedly vowed that, upon regaining power, he would dismantle every investigation, remove every prosecutor, fire Knox himself, and declare the entire legal process illegitimate. Knox saw the writing on the wall, so he moved before Hale could act. He took the investigation to completion, he filed the reports, he submitted the evidence, and he made sure no one could erase it. That means Hale has to answer for what's in that filing. The broader political reaction has been swift and varied. One side sees Knox's filing as long overdue accountability. The other claims it's a political attack. But what's different this time is that even some members of Hale's own party, those who still prioritize the stability of democratic institutions, have begun to acknowledge the gravity of the allegations. The evidence is too detailed. The documentation is too extensive. The witnesses are too numerous. The recordings are too explicit. This isn't something you can hand-wave as partisan theater. Judges won't treat it that way. The public won't treat it that way. And Hale certainly won't be able to ignore it. Let's break down the contents of Knox's filing in more detail, because the scope is massive. 1. Recorded conversations. Knox alleges that Hale can be heard directing aides to identify pathways to recalibrate vote tallies. Whether Hale meant it literally, politically, or metaphorically will be up to interpretation, but courts will hear it, and that alone makes testimony critical. 2. The alternative elector plan, emails, memos, and strategy outlines reveal a coordinated program aimed at generating competing electoral certificates. The question is whether Hale orchestrated this as a legal challenge or an unlawful scheme. Again, Knox argues Hale's direct involvement is documented. 3. Witness accounts. Multiple individuals who work closely with Hale have reportedly provided consistent descriptions of meetings, conversations, and instructions. Consistency among witnesses is devastating for a defense team. 4. Pressure campaigns on state officials. Knox alleges Hale pushed state authorities to re-examine certified results in ways that, if accurate, may violate federal statutes. 5. Communications with the vice executive. Messages between Hale and his vice executive, Leonard Pike, are central to Knox's reasoning that the actions were political, not presidential. If they were political, immunity dissolves. Now consider this. The moment courts determine these actions fall outside the boundaries of official duty, Hale loses the shield he's been relying on for years. And once that happens, everything changes. Compelled testimony becomes possible. Criminal prosecution becomes possible. Historical precedent shifts permanently. So what comes next? Expect a torrent of legal activity. Step 1. Formal briefs. Hale's attorneys will argue immunity. Knox's team will argue unofficial conduct. Judges will start parsing legal theories that could reshape presidential accountability for generations. Step 2. Hearings expect aggressive questioning from judges. Expect heated exchanges. Expect national media coverage on a level not seen since the Watergate era. Step 3. A judicial ruling. If the court orders Hale to testify, he faces an impossible dilemma. If the court blocks Knox's request, immunity widens dramatically. Step 4. Political repercussions. Congress may initiate inquiries. Civic groups will respond. International observers will dissect what this means for American stability. Let's be blunt. Hale's presidency, his political future, and the very definition of executive power are now intertwined with this single filing. This isn't just a legal battle. This is a systemic stress test for American democracy. Knox's filing asks one fundamental question. Is any political figure, regardless of status, accountable to the law? The next months will answer that question, and no matter where you fall politically, the implications are enormous. Because if Hale testifies, we enter new historical territory. If Hale refuses, we enter new territory. If the court rules on immunity, we enter new territory. If Congress intervenes, new territory. There is no version of this story that ends with, everything stays the same. Whether Hale emerges vindicated or condemned, this filing has already reshaped American political history. It's a legal earthquake with aftershocks still coming. And trust me, this was only the opening strike. What follows will be even more consequential. Stay tuned. Things are about to escalate.